All right, so let's talk a little bit about this idea of judicial review. We just kind of introduced that as being the ability of the court system to be able to look into the constitutionality of actions by other levels of government. In looking at that, there are three components of judicial review. The first is the power of the courts to decide national, state, and local laws invalid if they violate the Constitution. And again, remember that the Constitution is the foundational document of American government, and therefore the laws that are passed by levels of government, whether it's state, local, or national, cannot violate the provisions of the Constitution. All right? So that's the first component of judicial review. The second thing is that as a consequence of their ability to be able to decide on constitutionality of laws, basically in the United States we have something called the Supremacy Clause in the Constitution, which means that the U.S. federal government's laws are supreme over the laws of state and local governments if they conflict. So it's up to the federal judiciary to determine whether or not something conflicts with a state or local law at the federal level, and if so, that state or local law is in essence declared unconstitutional. The same thing is true with treaties that the United States government signs with other countries. They basically become enforceable federal law, and state and local governments cannot violate the terms of international treaties that we sign. So again, it's up to the Supreme Court and the court system itself to determine these things. And then finally, judicial review also refers to what we can call the role of the Supreme Court as the final authority on the meaning of the Constitution. So the Supreme Court being the court of last resort in the United States, at the end of the day, when the Supreme Court of the United States rules on something, that is the end of the question unless Congress decides to change the Constitution. So it's an enormous power that the judiciary has, particularly the Supreme Court, with their power of judicial review. But again, remember, the founders thought that it was necessary to be able to challenge the powers of Congress and of the President, who would be naturally stronger than would the judiciary. So let's take a look at a couple of examples of judicial review. So when we look at judicial review, it applies to all levels of government and the different branches within government. So remember, we talk about those concepts of separation of powers and talk about the concepts of federalism. The Supreme Court has the ability to be able to check everybody else in the American governmental system, right? So I won't go through all 6 of these cases, but just give you kind of a little bit of an understanding of how these things work. It's not very often that Congress basically passes laws that the Supreme Court judges to be unconstitutional. However, a couple of cases here. One in the case of Buckley versus Vallejo in 1976. We'd just come out of the years of Watergate, and President Nixon had left office. And what we saw was kind of a rising tide of public opinion hoping to change the campaign finance laws in the United States to prevent people from giving a lot of money to candidates. So in the Federal Election Campaign Act, what happened was Congress gave the power, basically started to regulate members of congressional races from spending too much money in elections. And long story short, one of the provisions in the Federal Election Campaign Act, commonly known as FECA, was a prohibition on individuals spending their own money on campaigns. Now, a guy named Buckley, James Buckley, was running for Senate in the state of New York, and he was independently wealthy and wanted to spend as much money as he possibly could on his campaign. He was told he couldn't do it, so he takes the case to court. And in 1976, the Supreme Court decides in the case of Buckley versus Vallejo that Congress and subsequently the President, by signing the Federal Election Campaign Act, violated Buckley's constitutional rights. You say, well, why? Well, essentially they said your ability to spend your own money is equated with your ability to engage in free speech. Right? So if I'm spending money on my campaign, I'm getting out a campaign message of what I would like the government to do, what I'd like to do if you make me a representative. And that speech is something that's protected under the First Amendment to the Constitution. And if Congress would limit the amount of money that I could spend on an election, they would be limiting my free speech under the First Amendment. Therefore, the Supreme Court in Buckley versus Vallejo strikes down the provision of the Federal Election Campaign Act that limits the amount of contributions that wealthy individuals can give to their own campaign, which now means that, say for example, I were a multi-billionaire, I could spend $50 million on my Senate campaign if I wanted to, because that's free speech, right? Another case, U.S. versus Lopez. Congress passed something called the Gun-Free School Zones Act early in the 1990s, and the goal was essentially, pretty much as the title states, that you would have, you couldn't have guns within X number of feet of schools. And they basically said that they had the power to regulate this under the Interstate Commerce Clause. And we've seen that before when we talked about civil rights. That was the way that we ended segregation by private parties. And the Supreme Court came back and said, well, we understand what you're trying to do here, Congress, and it's, laudable. We don't want guns near schools. But where do you really get the right to be able to regulate what happens on school property when that is in fact a state and local issue? And they said, and this is one of the rare times this happened, they said, we think you talking about the Interstate Commerce Clause is a little far-fetched, and basically overturned that law because they said that Congress did not have the authority to be able to regulate guns in school areas. Right? So two examples in which the Supreme Court overturned actions of Congress. The President, a couple examples here. One back in 1952, President Harry Truman nationalized the steel mills in the United States. And basically the owners of the steel mills were going back and forth with labor for the steel mills and the unions, and they were about ready to shut down, go on strike. And if you know the time period here, 1952, we're in the middle of the Korean War. In order to be able to fight wars, what do you need? Steel, right? You got to make ships, you got to make planes, you got to make bombs, on and on and on and go, ammunition. So basically, President Truman said, hey, you guys can't get your act together, you know what I'm going to do? I'm going to nationalize the steel mills, because we're in the middle of a national crisis. We're in the middle of a war. And basically, Truman takes over the steel mills, the government starts to run them, and the steel mill people were like, hey, wait a second, where do you get the power in the Constitution to do that? And again, the Supreme Court steps in. The Supreme Court says, we understand what you're trying to do, President Truman. We understand we're in the middle of the war, but there is nothing in the Constitution that gives you the power to do this by yourself, right? So eventually what happened was Truman made everybody sit down, they came to an agreement, and the whole thing was avoided. But the Supreme Court basically told President Truman that his action was unconstitutional. Another case that we've already talked about this semester is the idea of Nixon's White House tapes in Watergate. In 1974, in a case U.S. versus Nixon, what we saw was that President Nixon was asked to give his tapes over to the House Judiciary Committee, which was interested in running impeachment hearings against him. And he essentially said, I'm not going to do it because I've got executive privilege, which means that I don't have to turn these tapes over because they're confidential information that's been told to me. Congress said, well, we're investigating you. Our powers trump your powers of executive privilege. Supreme Court has to step in and say, well, you both have pretty laudable claims here, but we really think that Congress's right to investigate you trumps your ability to be able to claim executive privilege, and Nixon has to turn the tapes over, right? So again, an instance in which the Supreme Court is basically telling the president something that he's doing is unconstitutional. And a couple of pretty well-known cases, if you know anything about what the Supreme Court's done in its history. We probably know the cases of Brown versus Board of Education and Roe versus Wade. We've dealt with Brown before. So here were cases in which state and local governments basically segregated people in the educational system on the basis of race. And the Supreme Court in that case, as we know, said that that was unconstitutional and violated the African American children's rights, in this case Linda Brown, who kind of stood for all the students that were suing, violated their rights, and the state law was unconstitutional. Another example of that would be the case of Roe versus Wade in 1973. Basically struck down abortion laws in 40 states and came up with a whole system of regulating abortion on the terms of trimesters. So there's an instance in which the Supreme Court basically came along and again overturned a state law. So they've done it before. They have the power to look at what Congress does, what the president does, what state government does, what local government does, even what individuals in their own businesses do, or individuals themselves. So the power of the Supreme Court is fairly broad, but they generally do not use it all that often. They guard this power rather jealously.